A very good afternoon, our dear esteemed viewers. Welcome back to this week's another episode of the Community Show. We're very happy to have you back. My name is Douglas Drake, and I'm your host or moderator for tonight's conversation. Otherwise, let us start tonight's conversation. But before we begin the conversation, allow me to introduce our esteemed speakers or panelists for tonight's conversation. I'm going to begin with His Worship. His Worship Matanda Abubaker. His Worship Matanda Abubaker is he is a judicial officer he's a judicial officer with the judiciary here in Uganda, but also he's a law lecturer at Islamic University in Uganda. Thank you very much, Your Worship Matanda Abubaker, for joining us. And when the time comes, I request you to unmute and say hello to the viewers. Next to Mr. Matanda Abubaker, we are joined by a gentleman from Forum for Democratic Change, that is Mr. Mulindwa Walid. Mr. Mulindwa Walid, thank you very much for joining us. We're looking forward to having a wonderful discussion with you. He's a youth leader with FDC, or Forum for Democratic Change. Last but not least, we are joined by a student from Uganda Christian University. He's a student of law by the name Agaba Christmas. Agaba Christmas serves as a justice he serves as justice in the tribunal of Uganda Christian University. Thank you for joining us for tonight's discussion. Tonight, we are discussing the topic on bail, and that is entirely it. But before we get into the topic, let me briefly give my panelists time to say hello and maybe introduce themselves. I'll begin with you, Your Worship. Kindly unmute and say hello to the viewers. Thank you.
Yes, thank you very much, Douglas, for having me. It is a great opportunity for me to be back at the civic space, which is a home, because a few years ago, before joining the bench, I was hosting the Youth Roundtable, and before that, I was a regular panelist on some of these shows. And so it's exciting to be back. But more than that, to share on a topic that has to do with the fundamental rights and freedoms. And so I'm happy to be here, hoping to learn and share what I know. Thank you.
Thank you very much, Your Worship. We're definitely looking forward to having a wonderful conversation with you. And thank you for the good job you've done with Civic Space TV and growing it to make it, or to bring it where it is today. We are very happy and thrilled to have you back. Let's have Mr. Mulindwa Walid kindly say hello to the viewers and let them know about yourself. Thank you.
Good afternoon, colleagues, our viewers and listeners. My name is Mulindwa Lubega. I'm the National Youth League Chairperson of the Forum for Democratic Change. First of all, allow me to thank you, Douglas, for hosting me. And in the same vein, allow me to appreciate the Center for Constitutional Governance for this civic space, for allowing us to also tender in our contribution towards nation building, especially to this wonderful topic about human rights. Thank you very much.
Thank you. Thank you very much, Mr. Walid. We're definitely thrilled and happy to have you here, and we're looking forward to having a wonderful discussion. Last but not least, let's have the youngest panelist today, a student of law, and is very eloquent, but also has a very good grasp of the law. Agaba Christmas, kindly say hello to the viewers.
Hello, everyone. Good afternoon. Drake, thank you for inviting me today to have some deliberation. First of all, I'm very privileged and honored to be here, and I hope that what we shall deliberate on shall be informative as far as human rights are concerned. Yeah, thank you.
Thank you very much, Christmas. We're happy to have you here. Let's begin the conversation. Your Worship, this is a topic, or this is an area that you are an expert in. At the moment, you serve as a judicial officer with the Judiciary of Uganda, and to us to have this conversation without beginning with you would not do justice. And in order of hierarchy, you're my senior. I am a student of law as well, so definitely I need to follow the decorum. So tonight's topic is to what extent have the courts implemented bail as a constitutional right? You know that under the Constitution, it provides for the right for people to apply for bail, but people or the community out there do not possibly understand this. But I want us to, I would like you, as you unmute and turn on your camera, put this into perspective. Just briefly, create for us an overview of constitution. Just give us an overview of the constitutional rights to apply for bail in Uganda, and what does it entail, and what is bail for the ordinary Ugandan out there who is watching this and would hear this word bail but would not understand. Your Worship.
Yes, thank you very much, Douglas. First of all, I want to start with the disclaimer that whereas I'm a judicial officer in this discussion, I'm not speaking for the judiciary. That would require me to process some permissions. It's the public relations officer to whom power is delegated by the chief registrar, who are supposed to speak for the judiciary. So the views I'm going to share here are going to be mostly personal, and it just helping understand what bail is, and then maybe drawing from my experience. I want to start. I had reservations about the phrasing of the topic. To what extent? Because the topic appeared to me to be probing the performance of the courts, and again, in which discussion I would possibly not maybe participate, but also presenting bail as a constitutional right. I want to clarify that the right that is enshrined in the Constitution is the right to apply for bail, not the bail itself. So an accused person has a right to apply for bail, and then whether or not that bail is granted is reserved for the discretion of the court, which of course has to exercise that discretion judiciously. And in discussion, we are going to see what are some of the aspects that are considered. But to go back to the fundamentals, it's important for us to understand that by our Constitution, under Article 23, Clause 1, the Constitution provides that no person shall be deprived of personal liberty. And so the foundation, the fundamental right is that no person should be deprived of their personal liberty. So a Ugandan, or indeed any person, is free to have their liberty not restricted, to move as they choose, and to do what they want. However, there is a rider to that provision, which is that except in any of the following circumstances. And I want to emphasize two of those circumstances. One of them is when they are arrested for the purpose of executing a given court order, or upon reasonable suspicion that they might have committed a crime, or they are about to commit a crime. So that's where agencies like police, even judicial officers, though we rarely exercise that power, but the law allows us to cause arrests, and even an ordinary citizen is allowed to arrest. Arrest in what circumstances? Whether it is in execution of a court order, or on suspicion of someone having committed a crime, in which case we call them a suspect, or where they are suspected. So police can actually arrest you if they suspect that you're about to commit an offense. Now, after you have been arrested, this is where now the issue of bail and bond come in. And the basis for this can be found in our Article 28, the presumption of innocence, where even if you have been arrested, alleged to have committed an offense, or suspected to be about to commit an offense, the presumption of innocence is to the effect that you are held to be innocent until when you're proved guilty. Meaning, when you arresting you and even detaining you at police, or after having been arraigned in court, remanding you, is actually not a punishment. You are merely suspected of having committed an offense, and there must be investigations that have been done or that are ongoing, and evidence provided to establish whether or not indeed you committed an offense. And it's on the basis of that that the law envisages a situation whereby you should be able to be released to go back home and keep reporting to the authorities as the investigations go on, or as the case goes on, because in any case you are innocent. So later on we shall be looking at some of the things we look at, but I think that's fair now for us to understand that the basis for bail is the fact that a suspect remains that a suspect until when a case is proved against them, and they therefore have a right to, if we are still at police, you have a right to ask for police bond, which I want to emphasize that it is free. And then if you have been arraigned in court, you have a right to apply for bail. And then court can grant that bail based on different grounds. I suspect that we are going to discuss this further. And I think I want to first stop at that unless you have a follow-up question, and allow the other colleagues to also add a thing or two. Thank you.
Yeah, thank you. Thank you very much, Your Worship. That has been a very strong and powerful overview to what tonight's topic is, the constitutional right to apply for bail in courts of Uganda, what you need to know. So at this point in time, I'd like to bring in a voice of the people, someone who is not in the field of law, but someone from the community. And that is the youth leader from Forum for Democratic Change. I understand your party has been privy to a number of court cases, and a couple of times your party president has gone to court on and requested for bail, among others. Give us your understanding of what bail is.
Thank you very much. And I also thank His Worship, Matanda Abubaker, for that elaborate preamble about the subject matter. First of all, in my own understanding, a bail is a release of an accused person by court, either before trial or before the conclusion of the case, on condition that the released person will turn up for his or her own trial whenever required. Secondly, bail, the right to bail is a fundamental right which is guaranteed under Article 23, subsection 6 of the 1995 Constitution. It provides that an arrested person is entitled to apply to court for the discretion of the bail. So the Constitution gives the courts to which the person arrested and taken, it gives the powers to court to grant that person bail. So these two rights cannot be derogated. And in my own view, bail has about 3 forms. First of all, the cash bail, non-cash bail, and the mandatory bail. The mandatory bail, that is the bail after a suspect spending in a detention facility for almost 60 days. And that is my understanding of bail from the layman's perspective.
Thank you. Thank you very much for giving us that layman understanding of bail, which has been quite elaborate too. We are right now still having introductions. Let's have Christmas Agaba. You're a student, and I understand in the course unit called criminal procedure. We'll talk about this in detail, but briefly, I just want you to give us an understanding for the person out there who is not a student of law, to understand the significance of discussing this topic, especially in the context of the Ugandan legal system. Christmas? Christmas, are you there? Christmas? Looks like we have lost Christmas. Anyway, I'll get back to you, Your Worship. After giving us that quite elaborate overview, I now want us to go into understanding the right to bail. You earlier on said you talked about the right to bail. And Christmas?
Yeah, I'm there.
Yes, please, you speak louder.
Drake, first of all,
Christmas? Christmas, could you kindly work on that on the network?
Speak and
Maybe as you sort that out, I will get back to you. You just raise up your hand. When you're done, then I'll get back to you. But for now, then maybe I can first engage your worship. Your worship. I want us now to delve into the understanding of the right to bail. My question to you is, what does the Ugandan Constitution say about the right to apply for bail? Are there any specific articles or provisions that address this right? Your worship.
Yes, thank you very much. But there is some noise coming through. I don't know if you're getting the feedback I'm getting. Yes, of course, there are specific constitutional provisions, and it was interesting to listen to the what we call the lay person on the panel, because the lay person ended up actually making a submission like a lawyer, like any one of us who are exposed to the law on this panel, to cite Article 23, Clause 6 of the Constitution. And earlier on, I had raised Article 28, Clause 1, about the presumption of innocence. But he also brought on board the issue of mandatory bail, which is provided for under the Magistrates Courts Act in Section 76 of the same, for the case of capital offences being 180 days, and then the other offences being 60 days. So basically, those are the provisions. But maybe at this point, I would take you to the provisions in the Magistrates Courts Act that relate to the grounds. And if you can allow me, I would love to open it here and read them verbatim.
Thank you very much, Your Worship. That has been quite an elaborate submission. Christmas. I would like to get back to you. Earlier on, your reception intercepted or affected your submission. But as you had the submission of his worship, he clearly gives us the constitutional provisions that provide for the right to apply for the right to apply for bail and the rights to get bail. Right now, my earlier question that I asked you was, what is the significance of discussing this topic, especially in the context of the Ugandan legal system? Christmas? All right, looks like we have lost Christmas once again. Matanda, Mr. Walid, I would like to get to you. Mr. Walid, the conversation right now.
Okay, maybe, yeah, I remember I just requested for a moment to open.
Yes, please.
My act here to share the grounds verbatim.
Yes, please go ahead.
The grounds under Section 77, when bail is being considered, someone may be wondering, because I mentioned earlier on that it is at the discretion of court. So the question may be, what are some of the considerations that are looked at before someone is granted bail? And for purposes of the magistrates courts, we find this under Section 77. And it provides under 77.2 that when an application for bail is made by an accused person, the court has regard to the following. Number one is the nature of the accusation. So when court is considering whether or not to grant you bail, one of the things we look at before even doing anything is the nature of the accusation. Of course, it goes to state that if you're accused of murder, for example, that may not, the considerations may not be the same as to those of someone who has been accused of, say, maybe theft. The second is the severity of the punishment which the conviction might entail. We know that offenses attract different punishment, and therefore, when it is considering whether or not to grant you bail, we shall also look at the punishment. If an offense attracts a punishment of, say, 10 years imprisonment, the considerations may not be the same as those of an offense that, for example, attracts a fine of Uganda shillings 100,000. Chances are high that if the punishment, the punishment is more severe, then the chances of flight, someone disappearing are high, other than when the sentence is minimal. The court will also look at what we call the antecedents of the applicant. This just means the behavior prior to this application for bail. How have they behaved? Have they, for instance, while they were at police, were they given bond and they jumped it? How were they arrested? When they were summoned, did they appear willingly or were they looked for? Is this the first time they're appearing in court? How have they behaved before when they were released on bail? So all these are considerations that court will look into. Of course, those who don't want you to get bail will be arguing against it in these terms, and you also be trying to demonstrate that actually your antecedents are in your favor. The other very important consideration is whether or not the accused person applying for bail has a fixed place of abode, a location, a place of residence where they come from. This is why many times you see that when people apply for bail, we ask for LOC letters for the LOC to confirm that this is a resident of this place. Sometimes you have seen in court people presenting land titles. The issue, it's not so much about economic, your economic status to say maybe you're very wealthy, no, but it goes to prove whether you have a permanent place of abode, whether you have a location at which you can be found in case someone is looking for you. And usually it is important, or it is better when this is within the court's jurisdiction. And then the courts also inquire into the status of the accused person to measure whether or not they are likely to interfere with the witnesses or the investigation if it is still going on. Some offenses are designed in a way that the accused person, by maybe their position or their nature, they are likely to maybe harm or intimidate the victims or maybe compromise the investigation. So these are basically some of the factors that courts will look into as they exercise their discretion to determine whether or not to. Thank you very much.
Thank you. Thank you very much, Your Worship. You highlight very important issues when talking about the factors considered in bail application. You highlight the nature of the accusation, the severity of the punishment, antecedents of the applicant, and fixed place of abode. Agaba Christmas, I want to now get to you. I have two questions for you because earlier on you are facing challenges to do with your network. My first question to you is, what is the significance of discussing this topic, especially in the context of the Uganda legal system? But then secondly, as His Worship was discussing factors considered in bail application, my other question to you therefore in relation to what His Worship was discussing is, are there any circumstances in which bail might be more likely to be granted? And conversely, are there situations where it's less likely to be granted? Agaba?
I'm sorry you had lost me because my network was not all that stable. But I think what we should first understand is what is bail. The reason why I'm going to first define what bail is all about is that, anyway, I'll give that scenario later. But basically, bail is an agreement between court and then the accused, depending on the circumstances at hand and maybe with a reasonable amount of money as bond, of course. So the reason why I'm defining this is that sometime back there was a scenario where the complainant was the area LC1 chairperson. So that complainant, I remember when you're granting bail as a magistrate or a judicial officer, one of the things that the applicant or the applicant or the accused should present to is the acknowledgement letter from the chairman LC1. So this chairman LC1 being the claimant or the complainant deny the LC1 letter. He denied giving the letter to the accused person because he was the complainant, and the accused had allegedly stolen his solar batteries. So you realize that to the chairperson, he briefed that he's actually the one, he has a mandate to deny the accused person bail. So I think basically the significance of this call shall be to inform people who actually has the discretion to give or deny bail, who are the parties to bail. You as a complainant, you're not a party to the bail application. I think people should understand that. And then, I think your question was that are there circumstances where there is a likelihood that a person is likely to be given to be granted bail, and is there circumstances where he or she is likely to be denied bail? Yeah, they are there. First of all, when you look at the considerations that my predecessor or his worship already stipulated, you realize that if you have a fixed place of abode, I think that's one of the pertinent considerations. And how do they determine that you actually have a fixed place of abode? How? First of all, when you look at maybe the case of Sudiru Pareya versus Uganda, one of the considerations that was pertinent to his bail application was the fact that he had a house in Nyonyo. He had 16 wives and 25 children. You realize that you having maybe a house somewhere does not actually make you, be having a fixed place of abode. For instance, I might be having a house here, but then you realize that maybe I reside in, let it be Masaka or somewhere, yet I have a place there. So you having maybe a physical house there does not mean that you actually have a fixed place of abode. So if you present court that, well, yeah, I have a fixed place of abode, and depending on the circumstances at hand, I think you have a high likelihood that you will be granted bail. Then another thing is, how are your sureties? Are your sureties substantial? There's one time an applicant came to court, and his sureties actually never knew the stipulations that were on their documents. For instance, someone.
Christmas, maybe
Yes?
before you proceed, when you say sureties, we have people, ordinary people or the lay people who are watching, they will not understand who a surety is. Maybe you can break down that term as you proceed with your submission.
Okay, first of all, a surety, if you're an accused person and you're applying for bail, they always request you to come with someone who will undertake to make sure that you actually come to court on the very day that will be stipulated on the bail document. So that very person who undertakes to always ensure that you show up on the very days that shall be indicated on the bail document is what we call a surety. I think I'm very clear, Drake.
Oh yes, definitely, you're very clear. And
yeah,
thank you. Yeah. As you
so I was
conclude,
saying, as I conclude that very surety must be substantial. There is sometime back when someone came to court and is applying for bail, and then his surety doesn't even know what he's stipulated on. He doesn't know the village, doesn't know the sub-county. So I don't think, and of course, bail was denied because that surety cannot be considered substantial. I think, Drake, back to you.
Thank you. Thank you very much. I would like to engage Walid at this point in time. Walid, when you listen to the submissions of the learning friend Agaba Christmas and his worship, Matanda Abubaker, you get they give you a background of the law, what the law considers a fixed place of abode, as they term it with fancy words, among other factors that are considered. Does that look, for example, what Agaba Christmas was talking about, that there are some technicalities that court considers, that at times you may say, for example, the case is cited about Sudir, at times you may say you stay in a particular area, you bring the so-called sureties that it talks about, people who testify on your behalf, that it will actually appear. And then at times you're denied because the people or the ordinary person has not met that technicality. Does that therefore create a view to the people or to the outside world that justice is not being served?
Thank you very much. I wish to thank His Worship Matanda for that submission, and also the learning friend, Comrade Agaba Christmas, for his wonderful submission about bail. It has really put us into context of the subject matter. To begin with, these conditions at times they circumvent the notion of a speedy trial, and also as we are aware, there is a saying that justice delayed is justice denied, because if I present a surety with a permanent place of abode, a home, which is known, somebody has a national ID, and then the many times the lawyers on the other side would object on just flimsy technicalities. A case in point, one time I went to be a surety for one of my colleagues, and we presented almost all the whatever that was required of us, and then my colleague had an ID which was a duplicate, and the lawyer on the other side objected, and my friend was made to go back to Zira, was remanded back to Zira, and he was denied bail. We almost spent another week in trying to change to get another surety in something which I think it was really not ordinate in as far as dispensing justice was concerned. So in my own thinking, judicial officers need to review, or maybe Parliament need to review these kind of conditions to make them to make our people accessible to justice, such that the justice is not delayed, and in such circumstances not denied, because you can't say that this is a duplicate. You have come with a duplicate of a national ID, so you are not entitled to have to be dispensed with justice. So in my thinking, also the judicial officers ought to have a human face in as far as dispensing justice is concerned. Some conditions need to be really waived in order for justice to be dispensed. In that way, we the consumers of justice, the consumers of our legal system, we will feel that really our system works. It works for all of us, and also we shall be able to believe that really there is justice that we can really access. Thank you very much.
Walid, thank you. You bring a very nice perspective to the conversation, and the aspect of justice delayed is justice denied is an aspect that I would like to engage your worship on the issue of the suggestion by Mr. Walid that he thinks the factors considered for bail application should be reviewed. So as you submit on that issue, your worship, kindly guide us on whether you think the submission of my brother, Mr. Walid, should they go ahead and review these factors considered for bail application. But then my second question to you is in line of balancing rights and public interest. So how does the Ugandan legal system balance an individual's right to bail with concerns about public safety and preventing potential risks? Your worship?
I cannot hear Drake whether the Mr. Agaba.
Your worship.
Oh, okay. Yes.
Did you get my question?
I had the last thing I had was, is it review the factors? That's the point
All right.
at which I roast you.
I have two questions for you. From the submissions of Mr. Walid, he highlights the fact that there are circumstances, situations whereby they delay justice because someone didn't carry the national ID or whatsoever. So he suggests that they should review these factors. So my question to you, therefore, is the first question: do you think that these factors should be considered for bail application? That is from the submission of my brother Walid. Then the other question that I would like us to discuss is in line of balancing rights and public interest. But I think for now, you should first respond to that.
Okay, thank you very much. And now, first, I appreciate my co-panelists who have helped us and Agaba, and Agaba defined bail as an agreement or a compact or a bond between the court and an accused person for them to be released on condition that they return on a given date. And in that line, I want to clarify on something that Mr. Agaba mentioned, that it's important for our people to understand that granting of bail is at the discretion of court. And so as a complainant, for example, in a case, you need to understand that it's possible for the accused person to be released, because like I said at the beginning, they are the case against them. It may be misleading if we say that a complainant is not a party to that process. A complainant is a party to that process, and their views, if they have any reservations, for example, they know the antecedents of the accused person, or they know that the accused person is lying about having a place of abode, on any of the conditions, if they have information that can help the court adjust. So when we say they are not parties, we may exclude them and make it appear like they have no role in the process, yet they do. Now, to move on to your question, it is true, I agree with the suggestion by Mr. Mulindwa that it's important for us as judicial officers to have a human face and to be considered the reason why we are in these offices. I, however, also want to say that these conditions may not necessarily just be waived or removed, because remember, your balance and I think this speaks, though you haven't asked it yet, but you have to balance, and including those of the complainant. Sometimes by the time this person has been brought to court, it has been very hard to get them. Sometimes they're very high flight risk. And so it's important to have in place safeguards to ensure their attendance. For example, in the particular example which he has given, it is true, and actually court has discretion to release someone even without, you can release someone on their own recognizance, which means without them having to pay any, to be bonded to pay any money, without them presenting any surety, without them preventing any and presenting anything. These things happen. For example, the SASU and the rights of the child require that they are released unless their life is in danger. It may be a pregnant mother or who is sick or who is very elderly. And so the court has discretion to look at the circumstances and waive some of those.
Your Worship, we're losing you. Your network, your bandwidth is low.
Conditions are just things put upon to consider. No?
We are losing you. Your network is slightly becoming unstable now.
Yes, and I'm asking, how is it now? Is there an improvement?
Slightly better, slightly better. Maybe you can turn off the camera and continue submitting. It might help.
Okay. Let me try that. How is it now?
Better.
Yes, so I was saying these the conditions I spelled out, antecedents, nature of the offense, these conditions are not mandatory. It's not that the court is just invited by the law to look into them, to consider them as the court makes a decision. But ultimately, it's upon the court to look at the circumstances of the case and make a just decision. Now, if I can highlight that very issue where our brother talks about when they applied for bail and one of them had a duplicate ID. To be honest with you, it would be difficult to allow a surety as substantial when they have a duplicate ID, because then there are security features on a national ID, and we are trained to highlight them, to see them out, those features. So if I realize that the ID is duplicate, it might be fake. So for me, possibly what I would advocate for there is maybe to say the state needs to come up with facilities that can enable me as a judicial officer to see that this ID is genuine, maybe check in the system and be able to see that even when this person has presented a duplicate, the original exists. Because I know that many Ugandans, for fear of losing their IDs, they make duplicates and then move with the duplicates. And so in such a scenario, maybe you can check. But in the absence of that, it would be very difficult to accept a duplicate, because then someone can easily forge a national ID. And then before you know it, you have allowed a surety who is not even a national or whose address cannot even be established. So, but also it is important to note, and I think Christmas brought this out, about the LOC1 chairperson who refused to issue. That letter is not a must. The letter just helps to prove certain things. A surety is claiming that they stay in such and such a village. How can we confirm that? So we need a letter from the LOC. But it can be something else. It can be payment of meme or national water. It can be a letter from an LOC too. So it's important for us to know that the issue is for you to prove. So whatever you have that can prove that there's this place of abode, this is where I stay, and I'm resident in this area, works. So you should not be abused. You should not have a scenario where the LOC is misusing or abusing their power, thinking that you're at their whims. Without their letter, you cannot get paid. What court wants, what the law requires of us, is proof of those elements. And if you have something else that can help you prove, it can pass.
All right. Thank you very much, Your Worship. That has been a very elaborate submission. And right, I just want to briefly engage Agaba, then I'll get back to Mr. Walid. Christmas, if you're there, I want us to talk about balancing rights and public interest. When we listen to the submission of His Worship, Matanda Abubaker, on whether these factors for bail application should be reviewed, he agrees that he says yes, there are circumstances where these particular factors ought to be reviewed, but also there are situations where the courts of law themselves waive some of these factors. But right now, I just want us to talk about balancing rights and public interest. Agaba, you understand that there are certain high-profile cases that spur a lot of public interest, and definitely when it comes to one applying for bail, it will be political in a nature. So my question to you is, how does the Ugandan, how does the Ugandan legal system balance an individual's right to bail with concerns about public safety and preventing potential risks? Christmas?
Okay, thank you, Drake, for the question. Am I being heard?
Oh yes, proceed.
Drake, first of all, bail, okay, anyway, appeal is a creature of statute. I think we all know that. So it comes in a circumstance that we have instances where if you're denied bail, then you have no right to appeal against the denial. But for example, if you're in if you're in a magistrate grade 1, remember, if a magistrate grade 1 passes a decision, if I tell you to appeal against that decision, then you go to the High Court. But however, in instances of bail, if a magistrate grade 1 denies you bail, you have a right for revision. You apply for revision to the chief magistrate. So what if it fails? Then you go to the High Court. But then at the same time, if a chief magistrate denies you bail, you have a right to apply for revision in the High Court. And at the same time, if a judge in the High Court denies you bail, you have a right to apply for revision. You reapply in the very same court, but at this time, you appear you appear to a different judge. So I think one of the instances where the judicial system has tried to balance the rights of the accused person regarding application for bail, and then public interest. You realize that for the case of the accused person, he has that forum for revision. We have to understand that that's why it's like it's an exception, because if a magistrate grade 1 denies you something or passes a judgment that you do not actually agree with, then you have to apply to appeal to the High Court. But this time around, in instances of bail, you apply to the chief magistrate. You realize that's a forum. So this is in case of accused persons. Then for the case of the public, for public interest, first of all, when you look at the case, I think it's for Foundation for Human Rights Initiative versus Attorney General. Justice Esther Church, I think, was very clear. When you're trying to grant someone bail, put into consideration the victim of the actions of the accused person. For example, someone fired person Ed fired fired B's daughter. Then within I think 1 week, you realize that maybe the accused person is already you realize that the accused person is already within the community. So what does that portray? So if someone maybe depending on the magnitude of the offense, if someone committed a certain offense, depending on its magnitude, that's how the judicial system tries to weigh how is the offense. So if we release this very person within a week, how will the community look at the actions of the judiciary? So for instance, if it's a murder case, someone is alleged to have murdered someone, and then within a week, someone is already within the community that he has been granted bail. So when you put into considerations that too, first of all, on the side of the accused person, there is a forum for revision. Then on the side of the public or of the community, we consider the magnitude of the offense. If it's murder, if it's aggravated defilement, all those high profile offenses. So it will always be difficult to be granted bail within the shortest period of time.
Yes, definitely. Thank you. Thank you very much, Agaba. You provide us very good submissions on the situations where the court has tried to balance rights and public interest. For example, if the magnitude of the offense, you give us very good examples. If let's say the offense is murder, aggravated defilement, among others, which gives a very clear picture of what we're talking about. But let me get to Walid. My brother, Walid, tonight we're discussing bail, and for you, you're giving us a perspective of the person who doesn't know the law, giving us a perspective of someone who views the judicial system from a lens that is entirely non-legal. So my question to you is, I asked Agaba Christmas on grounds of balancing rights and public interest. Does it seem to you that there are situations whereby we have some, let's say, criminals who commit a crime, and the community knows that they've committed a crime, but court says, you know what, someone is innocent until proven guilty, but then they apply for bail and they're granted and they're brought back into the community? Does that in a way affect or make the judicial system feel like slightly sluggish or detached from the reality with the community? Mulindwa?
Thank you very much. Yes, allow me to discuss on this subject matters an end user of justice or the criminal justice system. First of all, the perception of the community, especially to somebody who commits a criminal offense and somebody who gets bail instantly, in my own view and the view of the public looks at that instance as it looks at that in a very bad way. First of all, when a crime is committed in a community, the community will rise up, and the fallback position will be the police and all other arms that dispenses justice, and that is to do with courts. So they expect that somebody should be kept within the facility for some good time until maybe at a time when the community sober up. That's the perspective of the public. But the legal perspective, it is very different. The way you have showcased it, that the presumption of innocence until proven guilty. And that's what really the court based on it, because any case is bailable. There is no any law that bars somebody from accessing bail. So there is a dispute. There is a discrepancy between the law and the public perception. And if I'm a judicial officer, I would balance both. For example, a criminal case, in my own view, I would really dispense justice. I would not rush to offer bail to somebody who has committed a very high crime criminal offense. So in my own view, I would really delay it a bit, because as judicial officers dispenses their discretion of offering bail, they also need to show that the law, they also need to show that justice is working. So in my own view, that should be left to the discretion of the judicial officer. But also, we also need to put into consideration the issue of having a corrupt judicial system, whereby for somebody even to access bail promptly, somebody need to go behind. I'm sorry, I'm not. I'm not pinning my senior comrade, His Worship Matanda.
It is well, Mulindwa. It's a community show.
I'm not pinning you. Yes, I'm not pinning you personally. I know you have a very clean record, but at least the system, the judicial system I'm talking about is very corrupt. Somebody just bypass, handle the judicial officer, sort him out, and then the next day bail even is offered even without any condition. And when somebody comes back to the community, he's also an insecurity to the community. So that's why many times you see even the community taking the law in its own hands. People beating up a suspect, somebody who has a case which is ongoing in court, but was out on temporary freedom on bail. So the community, the public gangs are up on him and maybe even kill him. So in order to avert such kind of scenario, my thinking, the judicial officer also need to put into consideration that delicate balance act to see whether if I send somebody back to the community, what would be the perception? Would the people perceive that the law is working or not? The same applies to police. If somebody is arrested, you are taken to police, you are arrested on a very high crime case, instead of committing you to court, CID processes the case and so on, DPP takes it over. The police just even use its own and they grant you a bond there and then. So somebody who has been beaten to the pulp by the community, he has been saved by the community, by the police, taken to police, that very day, somebody comes back. So what do you expect the community to really treat this kind of a person? So in my own view, that is something, it is up to colleagues on his worship Matanda and the entire judiciary to think about, to see how they can really balance it. Thank you very much.
Thank you. Thank you very much, Mr. Walid, for giving us that perspective. Your Worship, you definitely have to report back to the judiciary and inform them that at the moment there seems to be a very huge gap between what the community feels and think about the law and what exactly the law is. So definitely you possibly respond to, you briefly respond to Mr. Walid, but also I would like you to talk about the role of pre-trial detention as you respond to Mr. Walid. My question to you, therefore, is what are the potential consequences of prolonged pre-trial detention on the accused individuals, their families, and the justice system as a whole? Your Worship.
So it's feedback. Yes. Thank you very much. I actually do not have any response to Walid's submission because he highlighted the problem of corruption and also proposed a solution. And of course, this being a community show, I don't think this conversation would be complete if the issues of corruption do not come up because they are lived realities in our midst. But what I can say is that even from this discussion, you can hear that in our communities, many people treat remand as a punishment. So, which is not the case in the law, as Walid highlighted. So for them, once someone is arrested, for us, we look at the person as a suspect, alleged to have committed an offense. But for them, they look at that detention as a punishment. So when they are released, they get shocked and sometimes even fail to come to court and testify against them, thinking that the case is finished. And they also, when they go out, they may go bragging, showing that the case is finished, which is not the case. So I think that it is important for people, for Ugandans to understand that being detained at police and being on remand is not a punishment. And the person who is in those places is merely a suspect until when the case is proved against them. So, of course, it is also important on our side. And I read to you the first consideration is the nature of the offense. When considering someone for bond or for bail, of course, we have to be careful. Granted, they are just suspect, they are suspected, but they are suspected of committing something big. So when you're dealing with it, the gravity of the offense and the gravity of the sentence, as I mentioned earlier, should be considered. Yeah. So to look weird if someone, for example, is suspected of having committed murder, they are arrested and then tomorrow they are released. Yes, but if they are released, legally speaking, it is possible, as you have submitted. But I think on our end, we have to exercise caution. And I can tell you that in many cases, this caution is exercised. There are some offenses where you really have to work hard for you to secure a bond or bail because of the gravity of the allegation and the nature of the offense. Secondly, I want to supplement on a submission made earlier by Agaba about the revision and appeal processes on bail. In law, we also have these technical terms which sometimes take on different meanings. So, for example, when we use appeal, when we use revision, they may be hard for people in the community to differentiate, to understand. So it's important that we come clear. Yeah, so I was saying that if you apply for bail before a magistrate grade 1 and is declined, you have several options, like Mr. Agaba highlighted them. One of them is to go to the chief magistrate. Now, when you go to the chief magistrate, you don't apply for revision. You make a fresh application. The chief magistrate has power to look at your application and then grant the bail. But you also have the option to actually go straight to the High Court and apply, or even appeal, you can seek leave to. So usually grant bail, we actually inform the accused person that you have a right to apply before a chief magistrate to look again into this issue, or to even apply to the High Court. And if you remember the famous case of Dr. Kiza Besigye, for him, it was actually not a denial, but I think there was a colleague magistrate ordered for him to pay 30 million in cash. So he quickly applied for revision to the High Court, and that money was reviewed, I think, to 3 million or something like that. So we need to watch out there in differentiating the application, a revision, and then an appeal. But it's important for our people to know that when the bail is denied, like Agaba said, it's not the end. There are further avenues if you think that your rights have not, the discretion has not been exercised judiciously. And even on the side of the complainant, if you think that bail has been granted, but there is a problem, maybe the accused person does not meet the conditions highlighted, you also have a right through the DPP, through the state attorney, to cause a review of that grant. Now, moving on to your question, can I be heard? I'm not hearing anything. I hope it's attentive listening and not
Definitely,
me talking to
audible and
myself.
we can hear you. Please proceed.
Yes, yes. May you kindly refresh me on the second leg of the question?
The question was on the aspect of role of pre-trial detention. It is,
Oh,
what are the
yes.
potential consequences of prolonged pre-trial detention on the accused individuals, their families, and the justice system as a whole?
Yes, so first of all, suffice to say that prolonged pre-trial detention is bad and very dangerous for us. In fact, our constitution requires that if someone is detained, say at police, that they are produced in court within 48 hours. So because remember, we started from Article 23(1), which is telling you that no person, you have no right to deprive anyone of their right or freedom of liberty. So from that premise, if you're alleging that I've committed an offense, or you're suspecting that I'm about to commit an offense, or you claim that you're arresting me in enforcing a court order, you have to produce me in court immediately. So prolonged pre-trial detention is actually unconstitutional and should have no place in our justice system, and we should do all we can to see that it does not exist. While you ask what effect does it have? Of course, on the victim, you are infringing on their right to liberty, because as I've already explained. But also at the same time, you're clogging the system, because many of these detention centers, as you may be aware, are crowded, and so you're overburdening the facilities by not moving the case. You clog the system and create backlog. But also you create an avenue for abuse. That means if I know that once someone is detained, they can be held forever. If I have a grievance against Walid, I'll go and open up a frivolous case against him, knowing that by the time a trial commences, if it does, or by the time a determination is made, he will have suffered for so long. And we used to see this abuse with people being charged with the people who have like a debt. You find someone has a debt, maybe has failed to pay, and then they are charged with an offense, frivolous offense, like obtaining money by false pretense. But when the players know that this offense cannot fly, but they just hold the person for 3, 5, or given number of weeks to just push them to pay the debt, which is an abuse of the criminal justice system. But I know that there have been movements within the police system to stop this and stop detaining people. And there are so many decisions from different levels of the courts, especially the High Court, actually urging, for example, police and the prosecutors to always first carry out investigations before they arrest someone. If you remember the famous case of Council Nicholas Opio, when he was detained, eventually the court discharged him, and the High Court in that case offered very serious warnings and guidance to say that, don't just go arresting people, first carry out investigations. Then when you arrest them, arraign them in court because you have evidence, rather than just holding them when you don't have evidence and then you start to investigate. Thank you.
Thank you. Thank you very much, Your Worship, those have been very wonderful submissions on the in response to what Mr. Walid talked about and the role of pretrial detention, which definitely you make very eloquent submissions as to that regard. Let me get to Agaba Christmas. We're almost to the top of the hour, but quickly, Christmas, as you turn on your, as you get back, I would like you to discuss for us alternatives to traditional bail. So my question to you is, are there alternative forms of release or conditions that courts may impose on individuals instead of traditional bail? If at all they're there, how effective are these alternatives? Agaba.
Sorry, Drake, please pardon your question. I've not heard you.
The question is, are there alternative forms of release or conditions that the court may impose on individuals instead of traditional bail, and how effective are these alternatives, if at all they're there?
Okay, Drake, thank you for the question. When you talk about conditions, are you hearing me?
Oh yes, we can hear you.
Okay. When you talk about conditions that may be imposed on maybe the accused person in regards to his application for bail, yeah, some of the conditions for us, we know conditions like maybe fixed price of abode, but then we have those conditions are not mandatory, because the court can, on its own volition, maybe say, if you have a passport, a visa, can you please deposit your passport or your visa with the court? That's one of the conditions, because
Mr. Agaba, sorry, Drake, but I don't know if I'm the one who didn't understand your question. But Mr. Agaba, my understanding of Drake's question is, he's trying to say, besides bail, does an accused person have any other remedies upon which they can be released besides bail? Yeah,
yeah.
Am I? Is that, yeah?
Yes.
Yes.
Yeah. Okay. As I understood, it's like he as well asked whether there are other conditions under which one can be released apart from the ones that are stipulated within the legislation. Is it true, Drake?
Yeah. Yes, that also encompasses the question.
Yeah. So that's why I had to first say, without you stipulating that maybe you have a fixed price of abode or what, there is maybe a condition that you could first deposit your visa, your passport with maybe the court. The reason why I'm saying this, however much, I will go ahead and say this is not sufficient to the extent that it actually serves the law that the stipulations in the legislature, the legislation might actually pray. First of all, when you look at the famous anti-government activist called Kakwenza Ruchirabashija, he was told to deposit his visa and his passport with court. But within 3 days, the person was nowhere to be seen. And I think we all know who Kakwenza Ruchirabashija is. So you realize that if it was to maybe conclude whether the traditional conditions that courts may impose to restrict the accused persons, you realize they are not sufficient to that extent. So then when you go to other traditional, maybe what I may call alternative means under which a person might be released apart from bail, yeah. First of all, there is bond. Apart from bail, there is bond. That's one of the pretrial remedy. If maybe you look at article, is it 23? If someone has spent in prison more than I think it's 240 days for an offense that is tried by the High Court and other subordinate courts. So the moment he's presented to court, without anything, the person shall be released. And when you look at, I think it's also paragraph C, they are saying if a person has been on remand for more than 360 days for an offense that is triable only by the High Court, that person shall as well be released without anything, whether he has sureties or not. So meaning he shall be released on the court's volition without requiring all those conditions, present this and this. So you realize that apart from bail, depending on the circumstances of the case, if the person has alternative remedies that he can actually be released. However, those remedies, you realize that they are in one way or the other, they are a bit harsh, because if for you to spend on remand 300 days, it's actually unfair. I've been in court for more than 3 months. I've seen someone spends only 10 days in court, in prison on remand. By the very first day he's presented to court, you find someone, a man of over 35 years, is crying, meaning that conditions in the prison, they are not actually good as we may think. First of all, when you look at Mbara prison, the prison is estimated to be, they expect to be accommodating only 300 inmates. But there was one time we went there, the prison had over 1,200 inmates. So you can imagine such situation. The estimation is 300, but now the prison is accommodating more than 1,000. So this shows that even spending only 1 week in prison, it's not really good to that extent. So however much there is, maybe there's alternative remedies, 300 days, 240 days, they are not really good. I would prefer bail, because for bail it's as quick as possible.
Okay. Thank you very much, Christmas. We have reached the top of the hour of our conversation, and I would like to bring it to an end. But before I bring it to an end, I'll just quickly get the thoughts of Mr. Walid on the challenges in implementing bail. But as well, you could, as you highlight those challenges in implementing bail, you can go ahead and give us your concluding remarks. Mr. Mulindwa Walid.
Thank you very much. Allow me, before I go there, to add on what Commander Agaba has presented.
Please.
There are two. One, it is a prerogative of mercy by the president. The president is given power to pardon any accused person on whatever case. Secondly, there is amnesty. So all those are all alternative conditions for somebody to be released. But to go on the question about the challenges. First of all, we have set capture in my own thinking. Our criminal justice system is weaponized to harass the opposition and those who are perceived to be the opponents of the regime. We have seen in many cases where courts are really, the way they work, you could see that the state, the regime in power, is the one dispensing justice on behalf of the court. A case in point has already been mentioned by His Worship, when the Justice of Uganda Road told Dr. Besje that one of the bail conditions, you will have to pay a cash bail of 30 million. Very, very unprecedented. On a case, a flimsy case, a case of inciting violence, you cannot charge somebody 30 million. That means you are making it hard for somebody to access justice. So in my own view, that's why it was appealed in order for people for Dr. Besje to get justice. The second one is we have seen how security and parliamentary bodies overturning the decisions of the court. A court releases people, and they release the suspect, and thereafter you see Black Mamba coming on to circumvent the decision of the court. We saw it happening on Wednesday, November 16th, 2005, in a case where Justice Sempa Lugaizi Edman had agreed to offer bail to the 14 members of the 14 suspects of the People's Redemption Army, which Dr. Vesti was among. And immediately they learned that court has offered bail to the suspects. They went on to take over the doorsteps of court in a view to take over, to rearrest the suspect.
Yeah.
Hello? Hello?
I think you go on. He seems to have just had an interruption.
Okay. So in that, actually, it was only the lawyers who advised the suspect that no, we are not going to sign the bail papers, because we are fearful that if court releases you, then you'll be taken to a place which we are not sure of. So that's how the suspects were taken back to Luzira. So all of that is the black member were not. These were people from the state. So the state was behind this. We have seen it in many cases in the Buganda Road, where suspects are released, and thereafter people in uniform, people carrying guns within the precincts of court, takes over courts, and then they rearrest the suspects, and these suspects are taken away. So we see that as a rape on justice. So we think courts were confined, and also another scenario is in the arrest of Dr. Vesti, where he was remanded to be Luzira in 2005 towards the 2006 election. He was remanded to Luzira, spent there almost 2 months. Can you imagine a presidential candidate being nominated in Luzira? So, and in my own view, that showcase how our criminal justice system was weaponized to harass the opposition, and that is a result of state capture. But also, you may see that even the pressure from the
Walid, maybe as you conclude,
from the judicial officer. As I conclude, this is also I'm setting the challenges of yes, and the pressure from the magistrates. You may find that many judicial officers, while they are granting bail to especially political suspects, you see how they are very uncertain. What is the position of the state in this case? So in many cases, that's how they end up not offering bail on flimsy conditions, just because the state does not allow, the state does not want somebody to be released. So in my own thinking, if we handle such cases, if we liberate the criminal justice system, then we shall get justice. Justice will not be denied. Justice will not be delayed. Thank you very much.
Douglas, you may want to
unmute. Thank you. Maybe we can have Christmas. Christmas, kindly come in and give us a quick wrap up of your concluding remarks, and maybe way forward if at all you have any, but briefly.
Okay, thank you, Drake, the moderator. Maybe okay, I understand where our friend is coming from. By anyway, by the mere fact that he lies within one of the political parties, I understand the justification for his anyway submission. But he's right anyway, because that's the reality. That's the reality. It's not something that he's trying to figure out. we all know what happened in that famous case. I think it's the Black Mamba case. That's what he's trying to say. Yeah, so then at the end of the day, I think what needs to be done is to sensitize the masses and understand that some of them should understand that if you denied bail here, that's not the end. You can actually go ahead and apply in the higher courts. But some people actually take it that if you denied bail here, then that's the end of it. No, I think people need to be sensitized to that extent. Yeah, thank you, Drake, for hosting.
Thank you very much, Christmas. We're very happy to have you. Last but not least, Your Worship, I'm going to conclude with you. As you give us your parting shots, I would like you to highlight on the role of the legal professionals and advocacy. How best can you go ahead and create awareness to the masses, but in briefly, and you conclude. Thank you.
Yes, thank you very much. It has been a great discussion. And I want, before I answer your question and conclude, to mention some of the other avenues. Earlier on, you asked what other options exist besides bail. We have what is called the writ of habeas corpus in our constitution. And many people, I think even in the case of Kakwenza, this was applied. And this is an instrument that enables, if someone is missing, you can get an order of the High Court ordering whoever you have applied against, usually the heads of security agencies, to produce the person dead or alive. We have unconditional release, which has already been spoken about, but there was an amendment to the Magistrates Act and the Trial on Indictments Act this year by our parliament. And so you may want to check, you see that the days for cases tried by the High Court are 180, and the others, those below, are 60. So it's important to pay attention to those timelines upon which it becomes mandatory for someone to be released. Of course, there's also discretion exercised there, but there are provisions for that. There's also, you can also apply for unconditional release. Earlier on, you talked about pre-trial. You can approach court and make an application for someone to be released unconditionally if they have been held illegally. Then to move on to your question, I think that the biggest burden we have as legal professionals and players, and even for advocacy, civil society, is to disseminate. Shows like this are very critical. People really don't know their rights. They don't know what to do. They don't know where to go. And that's what even makes them susceptible to corruption, like Walid was saying. So I think for me, the beginning point is to use avenues like this and every opportunity you get to teach the people to understand the rights they have and how they can have those rights addressed. Maybe what I'd also forgotten, Agaba mentioned about the issue of detaining someone's passport as a condition for them to be released on bail. I would like to clarify that the conditions we talked about that are considered when granting bail, they are not considered only for denying or accepting bail. They are sometimes also considered for determining the conditions. So, for example, if the gravity of the offense is very high, the court may not necessarily deny you bail. It may grant you the bail, but put stringent conditions to say, for example, you cannot leave the country, and for that purpose, deposit here your passport. So the condition has been considered, but not to deny you bail. Or, for example, I have had cases where maybe it's a case of domestic violence, and the victim of domestic violence is worried that if this suspect is released, he's going to beat me again. And so, because of the nature of that offense, I could grant you the bail, but then I put you a condition that you don't have a right to go near this person at this distance. So don't approach this village until when this case is determined. So sometimes those conditions come depending on the nature of the offense and the allegations, not just looking at them to deny or accept the bail. My parting shot will be that let's understand that the law is here to protect all of us, and let's strive to see that we have a country that runs on the rule of law, because today you're a victim, tomorrow you're a suspect. Today I'm a magistrate, Tomorrow I might be a suspect. We have seen presidents, for former parliamentarians, anyone really is a potential suspect. So it's important that we work to build a system such that tomorrow when you are the victim, the law is there to protect you, rather than having a system that is porous and that's not understood or known and therefore weaponized against certain individuals of society. It has been a pleasure sharing, and I implore all of us to read the Constitution, to read these Magistrates Courts Act, Trial and Indictments Act, such that we understand these provisions and explain the same to the people who may not have the privilege to read. Thank you very much.
Thank you. Thank you very much, Your Worship, Abubaker Matanda, for taking your time, your busy schedule to join us for tonight's conversation. Thank you very much to Mr. Mulindwa Walid for taking your time to join us in tonight's conversation. And last but not least, thank you to Agaba Christmas for joining us to discuss the constitutional right to apply for bail in courts of Uganda, what we need to know. Otherwise, my name is Douglas Drake. I've been your host or moderator for today. Till next week, bye-bye. Stay with us and continue watching. Thank you all. Nice time. Blessed week. Bye.